So you use the word estates. What does that mean?
There's an awful lot we can do, but it's important we have these discussions early on.
Another life-changing event, shall we say, is, of course, marriage.
And I think that's what people sometimes underestimate, that it's not all about the white dress and the cake, but it's a legally binding contract that you're entering into, and the repercussions of that are vast.
And I'm just going to quickly touch on inheritance tax.
But I'm sure we'd both agree that an 18-year-old potentially inheriting a large sum of money might not be the best idea.
Hello and welcome to TV Lawyer, where today we're going to be talking about life-changing events, usually accompanied by popping the champagne, balloons and celebration, sometimes triggered by sadness. However, rarely does taking legal advice feature top of the list at these times, and I'm going to change that for you. Today I'm joined by my colleague Demi, who is an associate solicitor at Giles Wilson.
Hi, Melinda.
And we have lots to talk about.
We do.
Let's start with something close to my heart, and that is the birth of a grandchild, a baby in the family.
Congratulations on having your first grandbaby.
Thank you. So what should the parents of that child do? Why should they come and seek legal advice? Potentially, what should the grandparents do?
Absolutely. So the very first thing the parents need to be doing, even potentially before the baby is born, is coming to see us, because there's a lot of things we need to think about. And one of the things we're definitely going to need to either update or make, if they haven't done already, is a will. Because having that baby is probably going to change their desires for what would happen with their estates quite a lot.
So you use the word estates. What does that mean?
So when we talk about estates, we're talking about all of the finances and the money that there is that a person owns. So that's not just their property, but it can also cover their bank accounts, their personal items. Maybe there's some family jewellery or heirlooms that you might like to pass down to somebody. So anything basically that you own can then be covered by your will.
People are at this joyous time where they're anticipating the birth of a baby. But obviously there is also the fact that you're going to then be looking after that baby. Nobody wants to face the possibility of both parents not being there for the baby's life. But it's responsible to consider that. And as you say, what would happen to any money or property that the parents have? There's also something like death in service benefit, isn't there, for if you're working? There is.
But in addition to the finances, and probably more importantly than that, in your will we can include a guardianship clause, which will determine or at least express a wish of who you would like to look after that child if both parents are no longer around before they turn aged 18. Now, as you say, none of us want to think about that happening as a possibility. But realistically, when we're looking at your will, we have to look at a wide variety of scenarios. And that is one of them, because you don't want to be ending up in a situation where you and your spouse are not here anymore, and the person who's ended up looking after your child, your absolute love, has suddenly, they're not the person that you would have wanted to have that role in the first place.
Yes, and it is important that it's somebody that is aligned with your thinking. You can do a letter of wishes, of course, giving them some guidance, can't you?
You can, and you can make expressions in your will of maybe you would appoint some trustees for that child's money, and the trustees could think of advancing some money to the guardians to help with maintenance, education, school trips. There's an awful lot we can do, but it's important we have these discussions early on.
Yes.
And as you say, do it either by the means of a will or a letter of wishes. The letter of wishes can be a good idea for these kind of personal discussions because they don't become public documents, unlike the will. And so you can make them a lot more tailored to what you want.
Yeah, and personal.
Exactly.
Yes. And of course, all being well, these children grow and they become 18 and an adult, and 21 and perhaps a little bit more of a sensible adult.
We hope.
And at that point, it's usually a good idea, if you haven't revised your will in those many years, that's another triggering point.
Absolutely, because your will at that point probably is quite out of date. Maybe you appointed even your parents as the executors and trustees of the will when your children were very little, but maybe your parents are quite elderly themselves now. Sometimes people appoint brothers and sisters, but again, families can move apart as they get their own families. So at that point, then you might want to start thinking about having your own children as your executors and trustees, even if the idea of them doing that at age 21 seems very young. The chances are by the time that will actually comes into effect, they'll be a lot older and hopefully a lot more sensible.
So the important reason for making a will, of course, is that young children cannot inherit as people themselves. It has to be held on trust. So you want to determine how that trust takes effect in the will.
Exactly. The youngest somebody can inherit at is aged 18, but I'm sure we'd both agree that an 18-year-old potentially inheriting a large sum of money might not be the best idea. It's probably be enough to turn anybody's head. So in the will, we can set age criteria that they receive sums of money at. We can also decide maybe at age 18 they start receiving an income from the trust, but they don't benefit from all of the capital assets. So that's another possibility.
I was consulted the other day by somebody whose son has additional needs and is unable to manage his own money, even though he's in his 20s. And sadly, his grandparents had died and most generously had left a large gift to him in his will. So, of course, that is problematic. And
it is.
It's really important, isn't it, when people make wills, that they are really open about all the detail in their estate.
And that's absolutely one of the questions we ask. When we sit down to do a will, we have probably close to 100 questions that we go through, and it may feel like we're prying a little bit into people's circumstances, but that's because we really need to get to the bottom of what every beneficiary's needs are, what their needs are going to be in the future, how old they are they sensible with the money, is it a good idea for everybody to receive their money at the same time, or perhaps for it to be staggered a little bit more.
So those are all the details that you would go through. Another life-changing event, shall we say, is, of course, marriage. Mostly happy, but I know that you had a very challenging situation recently where marriage was entered into in perhaps not the most usual of circumstances.
Absolutely. It was a new inquiry that I took a couple of weeks ago, and on the first glance, it sounded quite simple and straightforward. A client's partner had called up to say, unfortunately, he had been diagnosed with terminal cancer. He'd been given a few weeks to live, but not to worry because they're going to be getting married tomorrow morning, which was a lovely thing for them to do just before he passed. And she just wanted to make sure that the wills that they had made with Giles Wilson about 20 years ago were still going to be okay. Now, to someone picking up that new inquiry, it might just be a case of looking at the will and checking, oh yes, everything seems fine. But to a lawyer, the moment we hear the word marriage, our minds immediately go to the fact that marriage revokes a will. Unless there is already a clause put into your will to say that the will is not to be revoked, then that marriage automatically is going to revoke that person's will. Now, this situation was complicated even further by the fact that the property that the couple were living in with their young children was owned in the client's sole name. So the person who was going to pass away very soon, the property was in his sole name. So if he got married in the morning and revoked his will, that means he dies without a valid will in place. Therefore, the intestacy rules come into effect. And we would have been in an incredibly strange scenario where his new wife would have a fixed amount of money that she would inherit from the estate and a portion of their property, but a portion of the property actually then would be passing down to be owned by his very young children. And that would have been very complicated at a time in their lives where they do not need complicating factors.
Yeah, exactly. And you've mentioned again the fact that there would be young children who, if you don't have a will, are entitled to inherit anyway, but then you have trusts created by accident, if you like.
Absolutely.
You've also mentioned the property being owned by one partner and not another. Property acquisition, buying a property is a life-changing event.
It is.
But I think that marriage, obviously, it was a happy occasion, poignant one for that couple. But I think that marriage at any time is a very important event. It unites a couple in a formal way, but in a legal way.
And I think that's what people sometimes underestimate, that it's not all about the white dress and the cake, but it's a legally binding contract that you're entering into. And the repercussions of that are vast, including, as we've said, the fact that it does revoke that will. It revokes other documents as well. So if you already had something like a declaration of trust in place from when you first bought the property with your partner and maybe contributed different amounts to that property, the moment that that marriage takes place, that split that you've set out in the declaration of trust might not apply anymore.
Hugely important point. So two younger people or two people buy a property, different shares, let's say 70% to 30%. They declare that this is how they own it, but they marry. That is superseded by the Marriage Acts.
Exactly.
If you then subsequently split up, determine what would happen. Of course, people can make a prenup in addition to making a will to remain valid through the wedding. So, here we come with our practical heads on, as you say, putting some strong advice in place. But the earlier the advice is sought, the better,
Completely.
isn't it?
It was such a shame that client had left it so late, but we did a really good service by him. We took the instructions for his will at 11 o'clock that morning, and by 3 o'clock that afternoon, both he and his new wife-to-be had valid wills in place that would not be revoked by the marriage the next morning, which I am informed took place at 10:30 at their homes.
Wonderful. I know some couples who have either been firstly divorced or bereaved, then look and find love again, which is wonderful, but they maybe are fearful of tying the knot because they think, oh dear, then what will happen to my children? I want my children from my first relationship to inherit.
Exactly.
But we can fix that, can't we?
There's always a solution, provided you tell us about the problem and come to us early enough so that we can sort it for you.
Yes.
Because there's so many different options when it comes to estate planning. We can find the right one for you. And that might be a case of amending your existing will to update it into a will that is more suitable for somebody entering into a second marriage and potentially even taking on stepchildren.
Yes, exactly. And one final topic that I think is perhaps, again, a bit of sadness and a bit of sort of good news is you may inherit, or your fortunes may change in a different way. So if you suddenly become a lot wealthier than you were, there's all sorts of other reasons then to come along.
Exactly. It's probably not something that comes straight to somebody's mind when they've inherited a sum of money, potentially from a grandparent or a parent. But it's a really good time to be looking at your own finances and start doing a little bit of your own estate planning, seeing what your assets add up to at the moment. Are you close to your own inheritance tax threshold? Maybe even this inheritance that you're going to get is going to push you over that threshold. And at that point, then we could start doing a little bit of planning and potentially redirecting some of that inheritance onto somebody who maybe needs it a little bit more than you.
So common scenario, person in their 60s inherits and thinks, well, actually, I'm pretty set up. I know what my pension is. I know where I'm living. But my children could do with some of this money.
Or even grandchildren. Even grandchildren.
So come and see Demi. Don't give it away without doing so.
Absolutely, because if you just start giving it away, then you are making a gift from your own estate. And that sum of money then is included within your own estate if you pass away within 7 years of making that gift.
Yes.
Whereas if you redirect the inheritance by way of a deed of variation, then that money never touches your own estate. It's completely exempt and it passes directly from the person who has passed away to the new beneficiary, never touching your estate in the middle. It's a very clever little document.
And I'm just going to quickly touch on inheritance tax, life-changing events. The budget last year introduced the potential for taxation on pensions. Okay, that's not coming into effect till 2027, but it's going to make a significant difference to some people. If your estate is worth over £1 million at the moment, then the further trigger point is £2 million because you lose some of the reliefs. And of course, bringing pension funds into that amount.
It can easily eat up a lot of the allowances, but I think what a lot of people forget is that £1 million allowance only applies to people who are leaving money to their lineal descendants and their children. But if you're somebody like me who doesn't have any children yet and might be looking at leaving money to nieces and nephews, and that allowance is a lot less than £1 million. So my pension alone could quite easily eat up that.
So the basic point is 350,000, isn't it?
325.
Excuse me. Where, if you have a property that you're living in, keep an eye on it, and now your pension to be added to that.
Exactly. And for most of us, if we start work when we're age 21 and we're paying into our pension till we're aged 66 or onwards, that's a long time and an awful lot of savings over many years. It's going to easily exceed that nil rate band quite quickly.
Absolutely. Well, thank you, Demi, so much for making us all face the reality of these life-changing events and the advice that we should be taking.
Thank you for inviting me, Melinda.
Thanks.